This is my ruling. By a notice of plenary objection dated on file on 25th of February 2022, the defendant applicant prays for the following orders. Number one, an order that the amendment to the 99 Constitution by the Third Alteration Act 2010 to vest jurisdiction in the National Industrial Court via Section 254C1 of the Constitution, respective of certain matter relating to or connected with employment, is invalid, null and void, and should be set aside. Number two, an order striking out the claimant's suit in limine on the ground that the National Industrial Court of Nigeria lacks the jurisdiction to entertain the claims and or hear and determine the subject matter of this suit. And for such further order or other orders this Honorable Court may deem fit to make in the circumstances. The grounds and particulars upon which the necessary preliminary objection is brought are stated in the application. This preliminary objection is supported by a 6-paragraph affidavit sworn to by a litigation officer in the law firm of counsel for the first defendant. A written address was also filed to accompany the objection. It was served in the applicant's affidavit in support of the objection the subject matter of this suit arising from or connected with rights and duties under a contract of employment in the Lagos State of Nigeria, not alleged to have anything to do with the federal government or any of its agency, is not a subject matter over which this court may exercise jurisdiction by virtue of Section 245C1 of the 1999 Constitution as amended. It was also about that the jurisdiction of this court, being a court established for the federation, can only be exercised as regards the subject matter with which the federation or government of the federation is concerned. Applicant also stated that the subject matter of this suit is a matter within the jurisdiction of the Lagos State High Court and not a subject matter irrespective of which the federation or government of the federation is concerned. That there is no feature in this suit to bring same within the jurisdiction, exclusive jurisdiction of the National Industrial Court. The other counsel for the applicant in his written address raised a loan issue for determination to it, and I quote, "Whether the Third Alteration Act 2010, whereby the National Constitution was amended, vests jurisdiction of the National Industrial Court of Nigeria in the subject matter of the claim hearing, and if yes, whether the act is not invalid, null and void, and this court lacks the jurisdiction to entertain the claimant's claims and or hear and determine the subject matter of this suit on court." The other counsel submitted that the parties to this suit are private individuals, but the subject matter of the suit is related to or connected with the claimant's alleged rights arising from a contract of employment of the defendant, and the relief sought are for salaries, gratuity, other entitlement, general damages, and costs. However, there is neither any allegation this manner of fact that the suit is related to or connected with banking or with the federal government of Nigeria. It was argued that the subject matter of this suit arises from or is connected with the right of the claimant arising under the contract of employment in Lagos State, that this court, being a federal court established by virtue of Section 6 and 5 of the 1999 Constitution for the Federation, is without jurisdiction to entertain, hear, and determine the claimant's suit. Counsel cited the case of Bronick Motors and Wema Bank and ECHO and CK Traders Limited. It was the submission of counsel that the civil causes and matters with which the National Industrial Court is conferred exclusive jurisdiction must necessarily be in respect of the subject matter within the powers of the National Assembly to make laws and not otherwise. Counsel referred the court to Part 1 and 2 of the second schedule to the Constitution, that the word employment is not an item in either the exclusive or concurrent legislative list. That employment in this case is a matter of simple contract of employment between an individual and a limited liability company, and there is no averment in the pleading that brings the employment within the matters in the exclusive or concurrent legislative list, citing Savannah Bank of Nigeria and Pan-Atlantic Shipping Transport Agencies Limited. Counsel, in conclusion, urged the court not to follow the decisions of the Supreme Court in Coca-Cola Nigeria Limited and Akinsanya, Skybank, and EU, and submitted that the amendment of the National Constitution, Third Alteration Act, provides Section 245C1 of the Constitution to vest jurisdiction in National Industrial Code of Nigeria respect of the subject matter relating to employment is invalid, null and void, and the National Industrial Code of Nigeria lacks the jurisdiction to determine this suit, and same shall either be dismissed or struck out, eliminated. In opposition to the notice of preliminary objection, claimant on the 11th of March 2022 filed a reply on points of law and submitted the following issues for determination to it. And I quote, whether this suit as constituted is within the jurisdiction of this honorable court, unquote. Another counsel for the claimant submitted that it is the claimant's originating processes that determine the court's jurisdiction, and from the fact averred in the statement of fact and the nature of the relief sought therein, the proper court with the jurisdiction to entertain this suit, the National Industrial Code of Nigeria, and not the State High Court as contended by the first defendant. Citing the case of Adetona and Igre Enterprises Limited, counsel also submitted that it cannot be overemphasized that matters relating to payment or non-payment of salaries and wages are central to labor, employment, and industrial relations. The National Industrial Code, by virtue of Section 245C1 of the Constitution, has exclusive jurisdiction on civil causes and matters relating to or connected with disputes arising from payment or non-payment of salaries and wages. Counsel submitted further that Section 245C 1K of the National Constitution as amended clearly state that the National Industrial Code is vested with exclusive jurisdiction to hear and determine matters relating to or connected with disputes arising from payment or non-payment of salaries, wages, pensions, gratuities, allowances, benefits, and any other entitlement of any employee, worker, political or public office holder, judicial officer, or any civil or public servant in any part of the Federation, and matters incidental thereto. It is a submission of counsel that the jurisdiction of court is derived from the statute creating or setting up the court. That in the case of the National Industrial Code, it is the Third Alteration Act to the National Constitution of the Federal Republic of Nigeria, the National Industrial Code Act 2006, and other subsidiary legislations, citing Section 54(1) of the National Industrial Code Act 2006 on the definition of an employee. The counsel referred the court to paragraphs 6, 7, 8, 14, and 42 of the claimant's statement of fact and submitted that the claimant is claiming some of money due to him as outstanding salaries, as outstanding salary arrears as a worker under a contract of employment. That's Section 91 of the Labor Act. Section 91 of the Labor Act on the definition of a worker was referred to by counsel, citing also the case of Mobile Producing Nigeria Limited and Udo. Counsel argued that labor is inclusive of contract of employment, and employment contract is a kind of contract used in the labor law to attribute rights and responsibilities between the parties. Counsel contended that since the claims of the claimant fall under the jurisdiction of this honorable court, the first defendant application is misconceived and should be dismissed. I've gone through the processes filed by the parties and their respective submissions. I've also noted the issues raised by the parties, and in determining this application, the issue I wish to address is whether this court has the jurisdiction to entertain the claimant's case. It is pertinent to state that for a court to have jurisdiction and the requisite competence to entertain a matter, the subject matter must be within its statutory jurisdiction. According to the applicant, so the matter of this suit, which arose under a contract of employment in Lagos State of Nigeria and not the federal government, is not a subject matter over which this court may exercise jurisdiction by virtue of section 245C1 of the 1999 Constitution as amended by the Third Alteration Act. But for the claimant, so the matter of this is within the jurisdiction of this honorable court of the 1999 Constitution. In determining whether the subject matter of the claimant's case is within the jurisdiction of this honorable court, I need to refer to the pleadings of the claimant, and it is settled that the jurisdiction of the court is determined on the claimant's pleadings, which is a statement of fact and not on the defendant's statement of defense. See the case of Honora and DRPC. Claimant stated in a statement of fact that he is a former employee of the defendant, but he was given a query and placed on indefinite suspension by the defendant. That he gave his notice of retirement after attaining statutory retirement age of 60 years, but he was not fully paid his entitlement. Hence, he asked for declarations that his indefinite suspension is wrongful and that the defendants are liable to pay his arrears of salaries and retirement benefits. With regards to amendment of the Constitution, it is worth noting that Section 9 of the 1999 Constitution of the Federal Republic of Nigeria states that the National Assembly may, subject to provisions of the said section, alter any provisions of the Constitution. By the Third Alteration Act 2010, the National Assembly altered the provision of the Constitution of the Federal Republic of Nigeria to establish the National Industrial Court under the Constitution, where Section 254C, among others, was introduced to confer exclusive jurisdiction on the National Industrial Court. The applicant has contended that the Third Alteration Act 2010 is void because the word employment is neither within the exclusive nor concurrent legislative list. It was held in the case of Sokoto State Government and Nawawi that the constitutional validity of a law can only be challenged in an action solely and principally instituted for that purpose. Here, the question I will ask is whether the applicant is competent to apply to invalidate an act of national industry, whether the applicant is competent to apply to invalidate an act of the National Assembly without instituting a separate action joining the necessary parties. In the case of Opara and Amadi, the Supreme Court per Unguta, JSC, has held that one section of the Constitution cannot derogate from or override the provisions of another section of the same Constitution. The supremacy of the Constitution in Section 1 thereof is shared and enjoyed by all the sections, including the amended section of the Constitution. See also the case of Oshimole and FGN and Aluko and President and Commander-in-Chief of the Armed Forces. It is the law that the Constitution is an organic instrument which confers powers and also creates rights and limitations. It is a supreme law in which certain principles of fundamental nature are established. Thus, once the powers, the rights, and the limitations under the Constitution are identified as having been created, their existence cannot be disputed in any court of law. However, the extent of such powers, rights, and limitations and their implications may be said to be interpreted and explained by the court in cases properly brought. See the case of Attorney General Ondo State and Attorney General of the Federation. Balongu and Governor Anambra State. I think Section 4 of the National Constitution as amended will be suitable and of immense guide to us here. It provides those legislative powers. Legislative powers of the Federal Republic of Nigeria shall be vested in a National Assembly for the Federation, which shall consist of the Senate and a House of Representatives. The National Assembly shall have power to make laws for the peace, order, and good government of the Federation or any part thereof, with respect to any matter included in the exclusive list set out in Part 1 of the second schedule to this Constitution. The power of the National Assembly to make laws for the peace, order, and good government of the Federation with respect to any matter included in the exclusive legislative list shall save as otherwise provided in this Constitution, be to the exclusion of the Houses of Assembly of States. In addition, and without prejudice to the powers conferred by Section 2 of this section, the National Assembly shall have power to make laws with respect to the following matters, that is to say, A, any matter in the concurrent legislative list set out in the first column of Part 2 of the second schedule of this Constitution to the extent prescribed in the second column opposite thereto. And B, any other matter with respect to which it is empowered to make laws in accordance with the provisions of this Constitution. If any law enacted by the House of Assembly of the State is inconsistent with any law validly made by the National Assembly, the law made by the National Assembly shall prevail. That other law shall to the extent of the inconsistency be void. Similarly, item 34 of Part 1 of the second schedule to the Constitution also mentioned the items relevant to this case as follows, and I quote, labor, including trade unions, industrial relations, conditions, safety and welfare of labor, industrial disputes, prescribing a national minimum wage for the Federation or any part thereof, and industrial arbitration. Unquote. Contrary to the contention of the applicant, it was held by the Supreme Court that by the provision of Section 4 of the National Constitution, the federal government, but also extends to any part of the Federation if the matter is in the exclusive legislative list. See the case of AG Abia State and AG Federation. Therefore, the contention of the applicant that the jurisdiction of this court can only be exercised as regards the subject matter with which the federal government or with the Federation of federal government is concerned is misconceived. It was the urge of the applicant on the court that Section 245C of the Constitution should be construed restrictively and that the Alteration Act is invalid. However, the Supreme Court has said in Nafi Rabi versus State that the Constitution shall be interpreted liberally and broadly, that a narrow interpretation that will do violence to the provision of the Constitution and fail to achieve the goals set by the Constitution must be avoided. And where alternative constructions are equally open, it is the Constitution that is consistent. It is the construction that is consistent with the smooth working of the system which the Constitution read as a whole has set out to regulate is to be preferred. See also the case of Skybank and EU. It was also held in FRN and Osahon that the Constitution is not to be construed with any ambiguity or mistake by its framers. It must not be subordinated to any other law, and in construction must not be subjected to indignity of deletion of any section or part thereof. I need to refer to Section 245C of the National Constitution, which is so clear and explicit. It provides us, notwithstanding the provisions of Section 254, 251, 257, 272, and anything contained in this Constitution, and in addition to other jurisdictions as may be conferred upon it by an Act of National Assembly, the National Industrial Court shall have an exercise jurisdiction to the exclusion of any other court in civil causes and matters, A, relating to or connected with any labor, employment, trade unions, industrial relations, and matters arising from workplace, the conditions of service, including health, safety, welfare of labor, employees, workers, and matters incidental thereto or connected therewith. B, relating to, connected with, or arising from Factories Act, Trade Union Act, Trade Dispute Act, Employees Compensation Act, or any other act or law relating to labor, employment, industrial relations, workplace, or any other enactment replacing the act or laws. F, relating to or connected with unfair labor practice, international best practices in labor, employment, industrial relation matters. K, relating to or connected with dispute arising from payment or non-payment of salaries, wages, pensions, gratuities, allowances, benefits, and any other entitlement of the employee, worker, political or public office holder, judicial officer, or any civil or public servant in any part of the Federation and matters incidental thereto. On court. The Court of Appeal in Eze and Ude stated that by virtue of Section 245CA and B, all matters regarding labor and employment have become exclusively reserved by the Constitution for the National Industrial Court. In other words, the National Industrial Court is by the said provisions vested with the exclusive jurisdictional competence to entertain and determine all matters pertaining to labor and employment. Based on the above, therefore, and considering the facts and circumstances of this case, I have no doubt that the applicant is bereft of competence to apply to invalidate an act of National Assembly without the presence of the proper and necessary parties before the court who would have been affected by the result of the decision of the court. I must say that it's not only the National Assembly that has stake in the Thorough Alteration Act, but all the state houses of assembly of the Federation and the federal government. Accordingly, National Plenary Objection is competent, it lacks merit, and is hereby dismissed with a cost of 30,000 naira in favor of the claimant against the first defendant.
We thank my noble Lord for that well-considered ruling, my Lord. We are most grateful for the cost. Thank you.
Thank you.
As the court pleases, we thank your lordship for a well-considered ruling.
Okay, Mr. Yusuf.
My Lord, we are grateful for the time the court has devoted in delivering this ruling.
Are you going to appeal?
My Lord, my Lord, we will just apply for CTC of the ruling first, then go through it there, and also proceed with the matter.
Okay.
As the court pleases.
Aja, Akani.
Yes, my Lord.
Since issues have been joined, we take a date for trial.
Very well, my Lord.
As the court pleases.
Yes, my Lord. Well, there are still pending applications from the second defendant's counsel.
We can move them on the day, man. On the third day.
Okay, it's
If there are applications to regularize, my Lord.
To regularize, okay, we can take on the next the adjourned date for trial.
Adia?
Yes, my Lord.
Date for trial.
Hey.
Oh my God.
Well, it's December.
December
8th.
Why not in October or November?
My network. Sorry.
Well, we have so many matters. There is a day Mr. Afeni is coming that he has about 4 matters in a day.
Okay. I can.
Okay,
Did you?
I'm back now. What date, my Lord? I can.
8 December.
A date in December.
8 December 8th.
December 8th.
Is it okay?
A minute. Yes, 8th November is not convenient. 8th December is not convenient. I'm before the learned brother. Or GJ.
It's the same court now. I said it's the same.
Upset.
What of 7?
And it's a trial matter too.
What of 7 or 6?
No, my Lord, 7 is not convenient for us.
5th.
My Lord, 6 is not convenient, my Lord.
What of 5th?
If we can we go to the
I'll take
next
it, my
date?
Lord. I think we can juggle it. 8th December, my Lord. Yes, sir.
Yes.
Yes, my lord. 8th December is convenient.
8th December is convenient. 8th December is convenient for everybody, my lord.
Okay, the Akani. Akani.
It is convenient. Yes, my lord.
Did you file your
It is convenient.
did you file your reply to the various
Yes.
statements of
Yes, my lord. Yes.
Okay.
That is what
Okay.
we are regularizing.
Eh?
It's one of the documents we want to regularize on that day, my lord.
Okay. Okay.
They have all been served.
Okay. So case is adjourned to the 8th of December 2022 for trial.
As
the court pleases.
We're most grateful.
Thank
I'm
you.
much grateful, my lord, for the industry.
Thank you, Mr. Yusuf and Jude.
Mr. Yusuf. Hello, the next one.
Yes, the Union Bank.
Union Bank. That's 412.
412. 412.
Yes. Okay, suit number NICN/LSA 412/2021 between Union Bank of Nigeria PLC and 1 Union Trustee Limited, 2 William Street Trustees Limited.
Yes.
May it please the court.
Yes.
Ibukunlu Alofe, my lord. Ibukunluwa is spelled IBUKUNOLUWA. Alofe means IBUKUNOLUWA. Alofe means my appearance is for the claimant respondent, my lord.
Respectfully, my lord.
Yes.
M.O. Obasikene. Obasikene spelled O-B.
Michael.
Obasikene. O-B-A-S-I-K-E-N-E, my lord. My humble appearance is for the first and second defendants.
Okay. Yes, Mr. Paul.
Respectfully, my lord. Paul Omoinjade, for the parties seeking to be joined as defendants in this suit. And appearing with me is Stephanie Konga Ojekere.
Okay. And so this is my ruling. But by an amended motion on notice dated on 5 and 28th of March 2022, the applicants pray to this honorable court for the following orders. Number 1, an order of this honorable court joining Cletus Okeke, Abraham Philip, and others as defendant in this suit. Number 2, and for such further orders, this honorable court may deem fit to make in the circumstance. The amended motion is supported by 34 paragraph affidavit and a written address, wherein the learned counsel for the applicants in its written address raised a sole issue for determination to it, and I quote, whether considering the fact of this case, particularly the supporting affidavit, this honorable court ought to grant this application. Counsel submitted that this court cannot be vested with jurisdiction to entertain the instant suit without the presence of all relevant parties before this court. Counsel referred the court to paragraphs 1 and 2 of the 1996 trust deed. It's a submission of counsel that the persons seeking to be joined as defendant in this suit are beneficiaries under the 1996 trust deed, and the instant suit by the claimant cannot be determined without their presence. The persons seeking to be joined are parties to several suits listed in paragraph 12 of the supporting affidavit proposed to by Kayode Oni and Abraham Phillips. They submitted that the pension right of the retirees under the defined benefit scheme in Union Bank of Nigeria PLC is not on the basis of the Pension Reform Act, but on the strength of the trust deed 1996, which is an existing pension scheme and thus protected under Section 50 of the Pension Reform Act 2014. That the entitlement of pension and review for the pensioners is provided in the 1996 trust deed are not derivable from the Pension Reform Act 2014. The counsel submitted that the Pension Reform Act, the in-house pension scheme ceased to exist